liability statute that imposes liability against the dog owner. But certain requirements have to be met. You have to show that you're on the property with the owner's consent and that there's no provocation of the victim towards the dog. So one of the things that we look at is whether the person was on the property with the owner's consent. Now, consent can be given expressly, that is, I'm inviting you onto my property, and it can be given impliedly. I'm not telling you on my property, but there are facts to suggest that I would allow you to come onto my property. So for instance, if I order a package, I'm impliedly giving you consent to come on my property to deliver the package. If my property is open to the public in general, there's no fencing, I'm impliedly granting the public to enter on my property for various reasons, whether it's to tell me that my car door is open, or whether it's to sell me something, right? So those cases are heavily dependent on the unique facts of each given case.
So theoretically, in this case, it's just the Jehovah's Witnesses going door to door knocking. If there was no fence, then I guess hypothetically the person is saying, yes, you may come and knock on my door without.
Well, that would be an issue that we would have to assess. It's possible. So the owner could say, listen, I did not give you permission to come on my property. I did not give permission for anybody to try to recruit me to their religious beliefs. But the statute, the dog bite statute, is not the only way to hold somebody accountable. You can hold them accountable on basic negligence principles. So for instance, if the dog owner knew that he had a dangerous dog, but his property was set up so that somebody could enter onto the property and the dog could attack that person, and the owner knew that that was a possibility, then it's possible to hold the dog owner responsible under general negligence principles. So if the owner knows that people come onto his property from time to time, and he knows that he has a dangerous dog, but he doesn't protect those people that he knows will eventually come onto his property, the owner can still be held responsible for a dog attack.
So is a sign like a beware of dog sign, is that for lack of a better term, a get out of jail free card for this kind of situation?
Well, I don't say get out of jail free, but it's certainly an important factor to consider. If the owner had dangerous dogs, no trespassing, don't enter my property, so a reasonable person would say, hey, I probably shouldn't enter the property, there's probably a dangerous dog, then the owner probably has the best chance of arguing that he's not responsible for his dog attacking anybody on the property that he does not invite on.
Does this kind of thing happen often in Washington State?
It happens all the time. In fact, we're just getting into the season right now, the dog bite, dog attack season in the spring, when the dogs become more aware of what's going on in their environment, they're outside more often, more people because of the weather are visiting other people's properties and so forth. So yeah, this is the season where we see more and more of these incidences.
When would it be an appropriate time to allow a dog to attack somebody? Is it like in the case of an intruder, a home invader, burglary?
Yes, certainly if there's an intruder, certainly if there's a burglar, certainly if your property, it's clear from a reasonable expectation that your property is closed off and you should not be entering onto the property. So usually that requires fencing. Signs are a good idea. So for instance, if you see somebody in your fenced backyard and they've got a hood on and they shouldn't be there and they look suspicious, allowing your dog to chase that person off would probably be well within the law.
And I guess it says the UPS driver was hoping that what happened to him would get some legislation passed. Do you know if anything has been stirred up in Olympia regarding this?
I don't think there has been, but it's not just Olympia, it's not just state law. Every city or county have their own laws concerning dangerous dogs, and we're also not aware of the city of Puyallup or Pierce County changing any of their laws in response to Mr. Backman's case.
Looks like that's it. Is there anything else you want to add?
Well, I would talk about this case in particular. So what I've learned is that the dogs actually escaped the fenced-in enclosure on the property. So that's significant because what it tells me is that the owner likely knew the dog was dangerous to people that didn't know, and that the owner failed to take reasonable precautions to make sure the dog couldn't escape. Most dogs that are confined in an enclosure are done so because the owner doesn't want the dog to get out. So if the dog is able to get out, that raises some evidence that the owner might have been negligent, failed to exercise reasonable care to keep their dog away from people that might visit the property.
So certainly, if somebody knows they have a vicious dog, it's, I guess what we're trying to get across is that the onus is on them to make sure that the dog does not hurt anybody unless it absolutely has to.
Yeah, so under the law, if you know your dog is dangerous, then you have a legal obligation to make sure that it doesn't hurt anyone that may come onto your property with your consent. Absolutely. So, and those are questions that need to be answered in the Arlington case, right? So if there's a history of this dog biting or attacking or acting dangerous in some way, then that increases the odds that this owner is likely responsible for the attack on these Jehovah Witnesses.
Anything else?
So,
Cool. Thank you very much.